Appeals is now open and in session. God save the United States and this honorable court.
Good morning, everyone. Please be seated. The court will now hear oral argument in the case of United States versus Hackler. Are both sides ready to proceed?
Yes, sir.
Yes, sir. Very well. Appellate, you may proceed.
Good morning, may it please the court. Major Jeff Liebenguth for the appellant, private first class, Jeremiah Hackler. Court's permission to reserve 5 minutes of my time for rebuttal.
Very well.
I'd like to break my argument up today into 2 parts. First, I'd like to talk about why, despite the fact that the accused pleaded guilty and failed to challenge the specification at trial, that this court should not liberally construe the specification here. And second, I'd like to talk about why, even if the court does look at the specification in a liberal light, the terminal element is simply not applied. But to the first matter, this court should review the specification with the same critical eye the CAF used for the Foster specification.
Major, let's presume that we do that, of course, and we view it with a critical eye. Just putting an old trial judge's hat on, didn't your client again and again and again and again throughout the tenure of the transcript of this trial tell us, 1, how guilty he was, 2, how he wanted to be guilty, 3, articulated and understood the trial judge's terminal element explanation and signed a pretrial agreement that articulated how guilty he wanted to be and was, and accepted the fruits of that agreement? How has he not waived any prospective error in this litigation?
Well, the reason he didn't waive it, Your Honor, is because under Marker and Mayo, operative at the time of his trial, now overruled, couldn't prepare a proper defense from the outset. That is, if he wanted to contest this specification at trial, he would be forced by this judicially sanctioned practice of totally omitting the terminal element from the charge to go to trial having no idea what the government's theory of criminality.
But wasn't this judicially sanctioned practice, which I would contend you're correct under Mayo, indicated, and I believe it articulated that any assault on the assumption of the terminal elements being implied would be, and I believe the term was meritless.
Yes, Your Honor.
That goes, or at least begins to go down the wayside, does it not, with the outcome in Medina and several other cases, Schmuck, all the way down the line? I mean, when you look at the timeline here, wasn't your client and certainly his counsel on notification at trial that this was an area fruitful for possible attack? And indeed, as we saw in Fossler, at least one counsel had the temerity to launch such an attack, and the attack turned out to be successful in a contested case with a filed motion.
Yes, Your Honor. First, we point out that the government's totally flip-flopped on bringing Medina, Miller, and Jones here. Before this court in CAF, they said that Medina, Miller, and Jones had no import because those were LIO cases. Now they want to say that, oh no, this terminal element was being assailed, this principle at the time. We disagree. In all of those cases, there was an actual legitimate offense on the charge sheet from the get-go. Now the LIO is obviously a little bit different. So that's a huge distinction. Here we started out with a defective specification, and under Marker it was permissible. But when Marker came out in 1952, we strongly believe that it was squarely in conflict with Cook and Carl, which was 75 years earlier. So 135 years after the Supreme Court had settled the matter, we're again arguing of whether or not about whether the terminal element was implied, although I know this court did go into that in its Fossler opinion. Quite frankly, it didn't really need to. It could have said in a few lines that no, Marker and Mayo, Major Liebenguth, say that you don't have to put it in there. Your client's going to lose on those grounds, and that's it. So, in the fact that we brought it up on appeal, Your Honor, trial counsel simply had no reason to to challenge this. As a matter of fact, in Fossler, as Judge Efron pointed out in his dissent, the trial counsel there gave no reasons, no case law, no regulation. He pointed nothing in the manual to support his position that the terminal element had to be expressly alleged. And in that case, the trial judge simply flipped to the manual when that motion was brought, said, no, it says right here that they don't have to put it in. So that's why we disagreed with any notion of waiver in this case, Your Honor. At the time of marker...
Let me ask, why doesn't, the government has argued that plain error is the standard that we ought to be applying, is the legal test we ought to be applying. Why do you think that plain error is not the correct legal analysis?
The reason we don't, Your Honor, is because we had a case very recently where if they're going to apply plain error, CAF would have. That's Fossler. They found that the terminal element was not implied.
Why would they apply plain error in a case where there was an objection? In Fossler, there was an objection. We're dealing with a case where there was no objection here in United States versus Hackler.
Yes, Your Honor. I don't think it, because under their case law, it's always been a de novo review. All of the case law says this. Even in Gross, this court's opinion, where it was a guilty plea, there was no plain error review. This is a well-settled matter in our view, that if the specification is found to be defective, it's fatally defective. There's no plain error review. The government wants a plain error review for a prejudice analysis. CAF has never done a prejudice analysis. They didn't do it in Fossler, and they didn't do it in Petrie and Lorenzen. Petrie is a guilty plea case. Those are 50s cases, and I know this court is not.
Well, Petrie, though, those cases, again, the problem in Petrie is that the factual allegation was insufficient. It wasn't a problem of missing elements. It was a problem of a factual allegation that was wrong, where they failed to indicate what the status of the individual was so you could tell if the Texas law on underage drinking applied to him. It had nothing to do with elements.
Yes, Your Honor, but they still found that the specification itself was defective, and we don't really see a difference between, that is, if you don't put an element, and I think you're missing a huge factual allegation. That is, in this particular case, because here we have a unique situation where the element is prejudice and services creditor, both an element and a theory of criminality. We don't find that anywhere else in the UCMJ. And so when
is it your client's position that under Fossler, the way it has been published, that a element of an offense can never, under any circumstance, be implied?
No, Your Honor. There are times that it could be. Now, that brings up an interesting point. Judge Baker, in his dissent, said, look, I think the term element is implied in this case. The majority disagreed. He pointed out, if you disagree, when could it ever be implied? The way it would be implied is if you used language that was similar to that. That is, if they said that, look, he broke restriction, and this had a negative effect on the morale of the unit, or it in some way negatively affected the public's perception of the military. There we have implied. This is in full accord with Resendez-Ponce, with Klein and Whitman. All these cases where they simply looked at language in the specification and looked to its meaning. That's what Fossler did. They said they looked to the word.
Counsel, doesn't breaking restriction necessarily constitute an offense?
No, Your Honor.
Is it distinguishable from Fossler?
Not at all, Your Honor. It's distinguishable in the sense that it's a different act. But it's exactly like Fossler in the sense that Congress hasn't made breaking restriction a punishable offense. It's just an example of conduct, as Cass said in Jones, that may meet all of the elements of Article 134, which then may be a crime. And that's one of the real problems that your question brings out, Your Honor, is that over the past 60 years, the erosion of the importance of this element has gone so far that breaking restriction is viewed as the crime. Adultery is viewed as the crime. In fact, CMA viewed adultery as the crime in United States v. King. And Judge Beal, if you recall, we talked about King in the Fossler argument. You asked me, there was an adultery specification in which terminal elements in accord with marker were not put in there, but they didn't allege that he was a married man. And they set it aside because it didn't. And yet, that's not the crux of an Article 134 offense. And you asked me, Judge Beal, did it state in believe it did. They said that he had sex with a woman who was not his wife. If you fill in and it was prejudice, good order, and discipline, you've satisfied all of the elements of Article 134. You have the first element, which is the act. And
But
this
is
how
there any way one could break restriction without satisfying Clause 1?
With that, well, there's certainly some defenses, Your Honor, that could be brought out. Yes,
That's not the question before you. Isn't Clause 1 axiomatically implied in the stated offense?
No, Your Honor.
Please give me an example where that would not be the case.
Where breaking restriction would not be the case, Your Honor?
No, where breaking restriction would not axiomatically be prejudicial to good order and discipline.
Well, if it was a justified breaking of the restriction, that is, if he had a duress defense, Your Honor, that would be.
But that's not the case at bar, is it? Your client.
Well, you asked me if there's ever an issue.
Yeah, but
in every case, Your Honor.
yeah, but I'm talking a case in which an individual is pleading guilty to the offense, and the sovereign, tragically, is too derelict but to add the terminal element into the offense. Isn't it axiomatically implied?
No, Your Honor.
Why not? How not?
Well, that's
How is it not?
It's just, Your Honor, that's probably the most, I think, difficult question I've searched for an answer for, only because my answer is so simplistic. As if the government got out here and said, 2 and 2 is 5, and I said, no, it's 4. You asked me why. It would be very difficult to explain other than say that, well, there's these first principles that are applying, that it just isn't. And so if we look at the words breaking restriction, and we just fill them in the same way that you find in Resendez-Pons or Klein and Whitman, what does breaking restriction mean? And in our brief, we point out that it would be silly for us to ask for any further explanation of what breaking restriction means. We think it's very important that because of the past 60 years where the term element has become so unimportant, that when you simply put those words in there, rather than lead you to any terminal element, it leads you further away. That is, it looks like the breaking restriction, because certainly we agree that breaking restriction, taking away all of my attempts to show you ways that it would not actually satisfy the terminal element. That's not the question. We would agree that breaking restriction is almost always going to be prejudicial to good order and discipline. There may be examples where it wouldn't be, but we'd agree that in general it would be. But the question is not whether it satisfies the terminal element, that is, whether it is prejudicial, but whether it necessarily implies the terminal element. And to dovetail off that is, we have another element which is very important, that is the service discredit. We don't know what the government theory of criminality is here. That is, what if they were forced to put the terminal element in there, and they alleged that he broke restriction and that it was service discrediting? I think a lot of defense counsel...
Wasn't the remedy at trial for the appellant or the accused to ask for a bill of particulars in that regard?
No, Your Honor. In fact,
why not?
Well, first, a bill of particulars does not, as they said in Russell versus United States, and as Kath pointed out, possible, doesn't cure a defective specification, Your Honor. But second, under the same principles, Marker and Mayo that simply said you don't have to put the terminal element in.
But you seem to be complaining that the accused had no idea what to defend against. Wouldn't a bill of particulars have satisfied that?
No, Your Honor. I think that for the same reasons that asking for a bill of particulars or challenging the specification as the appellant did in Fossler is the same way, or a different way, asking for the same thing. That is more specificity, notice of what he has to defend against. And under those circumstances, we don't think a bill of particulars would have cured anything. And I think we have to really imagine this discussion between the defense counsel and his client before a trial in cases like this. That is, defense counsel says the government has charged you with an Article 134 offense. They're going to have to prove service discredit or prejudice in addition to this act they've charged. And the accused says, well, which one are they going to try and prove? Well, I don't know. They don't have to tell us. And so you go through this. Defense counsel will think, well, how are you going to prepare my defense? you get into this dance that I kind of talked about in my brief. He doesn't know what to defend against. He can't prepare a proper defense. The best thing he can do is prepare for both, while the government may or may not be preparing for just one.
Explain what any of that has to do with the guilty plea.
Well, Your Honor,
the government didn't introduce one piece of evidence to convict your client.
Right, Your Honor. And if I cannot properly prepare a defense, and I can mitigate my punishment exposure by taking a pretrial agreement and pleading guilty, I think this is a very real danger. And so does the Supreme Court, so does CAP. It's the very danger that they need to protect against in Russell versus United States and Medina, Miller, and Jones. That is that you know what you have to defend against, and so you could probably...
Can you point to anything in the record that suggested in any way this appellant had no idea of what it was that he was facing? In other words, during the plea colloquy, did he suddenly sit up and say, "What do you mean there's a second element, Your Honor?" In other words, when the judge read him the second element, and he said, "Well," and the judge says, "Well, was it service discrediting or conduct prejudice or good or discipline?" At that point, did the appellant say, "What do you mean? I've never heard those." I mean, the answer is no. What he said was, "Oh, it was prejudice or good or discipline, Your Honor,"
Yes, Your Honor.
and then provided a reason as to why it was. Is
Right.
there anything in this record to suggest that your client was in any way misled, in any way deprived of the ability to prepare, or in any way confused about what he was defending against?
But it's not in the record, Your Honor, but it would be unfair to look to the record, in our opinion, to do that, Your Honor.
All right, well, let me take you up on that one step further, because that part of your argument strikes me as being somewhat circular. You've argued that he doesn't object because the case law has called these objections meritless. So he doesn't object because it's meritless, but he only knows that it's meritless if he knows what the elements are. In other words, if he's not raising the objection because the element isn't there, because the case law says that it is meritless, he knows the case law that talks about the element.
We agree, Your Honor.
As my law school professor would say, your argument proves too much. He's
Your
got
Honor,
notice. He knows it, and he knows it's a fool's errand to object. Therefore, he knows the elements.
Right, except when you take it to the next step, Your Honor, which is the uniqueness of Article 134 is that there are two terminal elements. We speak of it generically as the terminal element, but there's two. And
Okay, but how did that affect your client? I mean, I understand the theoretical, hypothetical. How did that affect your client who entered a plea of guilty, who has a pretrial agreement in which he signs it indicating he will plead guilty to charge for violation of 134 or breaking restriction? How did it prejudice him?
Well, Your Honor, there's no way we can there's no way I can answer a question if I don't use theoretical underpinnings. That is, if the court does not buy the fact that, or our argument that Marker and Mayo created an atmosphere in which it was impossible to properly prepare a defense, there's no way for us to show it.
Why did that create an atmosphere where it's impossible to prepare a defense? Because hypothetically, some guy might not know what the terminal element was? I mean, wouldn't that apply?
Not that they don't know what the terminal element is, Your Honor, but that they don't know what the government is trying to prove.
Okay, distinguish that then with larceny cases, where all the specification says did steal the property of another. He doesn't know if it's a withholding, he doesn't know if it's a taking, he has no idea. How could he possibly prepare a defense?
Well, the difference, again, Your Honor, is that, again, Article 134 is unique. The element and the theory of criminality are the same. And that's a huge distinction. In every other UCMJ offense, in all of the cases...
No. Answer the Chief Judge's question, which is, under a larceny scenario, how would it be that your client would be able to discern the government's intent, the government's theory of the litigation, be it a withholding or an obtaining? Isn't your client placed in the exact position you're articulating here? Yet we don't seem to see that raised as an appellate issue in larceny.
It should be, Your Honor. Absolutely. If there's these different theories of criminality, Russell couldn't be clear on this matter. You can't come to trial thinking it's going to be a withholding, and then all of a sudden the government sees it unravel and shifts to a taking. That is exactly what they need to...
Yes, but you could come to trial as the accused and plead guilty to the theory of your liking.
Correct, Your Honor. And only because Marker and Mayo put you in a position where to do otherwise would be foolhardy, because you expose yourself to this greater punishment. You know what you're getting if you're pleading guilty. That's the crux of our argument on that part. But we're still talking about prejudice. So rather than, see, I have like 5.5 minutes left, Your Honor. If we're talking about prejudice, first we have to find out why we're, I think, applying a prejudice analysis, because CAF never has. And it doesn't matter whether it's a guilty plea case. I mean, the language in Petrie is extremely strong. You know, that if all of the elements are not there, guilty plea does nothing. It vitiates a conviction. They warn the government to put all of the elements in. They even warned the government in Flag that you can't rely on the sample specifications. If they're not sufficient, you have to do more. And it's kind of interesting that in Fossler, as Judge Efron pointed out, the defense counsel there pointed to nothing case law-wise, manual-wise, or regulation-wise suggesting that the term element needed to be there. He was relying on his first year of criminal law in law school. He taught the very simple concept that offenses have elements and they all have to be put in a specification in order for it to be valid. And you know, that Cook and Carl used to describe it as ingredients. You know, charge has ingredients. You have to have all those ingredients in there.
Isn't the terminal element in Article 134 just qualitatively different in its nature? I mean, elements are objective facts that need to be proved or disproved in a court of law. Whereas, you know, whether or not something is prejudicial, good order, and discipline, or whether or not it tends to be service discrediting, isn't that kind of a qualitative conclusion that you reach based upon a finding of the actual objective facts that predicate the offense?
I think I agree with that, Your Honor. I don't see how it affects our argument, though, in the sense that...
Well, it goes to the notice element, because if you agree that the objective facts tend to be service discrediting or prejudicial, good order, and discipline, doesn't that satisfy the notice problems that are addressed squarely in Fossler?
We think not, Your Honor, and the reason is we believe that a breach of restriction alleges the act. For instance, in this case, would not be service discrediting. Excuse me. Yes, would not be service discrediting. We think to argue that by the government would be problematic. So if you buy into that, and the government actually came forward and alleged service discredit, as a defense counsel, I would like to try that case.
Well, let's go back to the larceny case situation. Okay, he's charged. Your client's charged with stealing something. Okay, you don't think he wrongfully obtained it. You don't think he wrongfully withheld it. You think he took it wrongfully, right? So you're going to go in there and you're going to plead guilty, wrongfully taken, right?
Yes, Your Honor.
Those are objective facts. You know, the elements are met in larceny.
I haven't had a larceny case yet to attack, Your Honor, but I think it's open to attack at this point. I don't think you can just say, well, one of them, get ready. That's not to say that there's not cases out there that have allowed that. But none of them occurred in the context that this one did. That is, Marker and Mayo are sitting there saying, hey, defense counsel, you're going to be laughed at if you bring this argument into a trial court. And I think the defense counsel and Fossler just didn't know military law as well as maybe some other people did. Because otherwise they wouldn't have brought it up. Or if they did, they would have been clamoring on about Resendez-Pons and all these other cases that support it, not just this kind of basic conclusion. And when you look at the cases court cited in the specified issue, Harvey, Cox, and Awad, all of those cases are wrangling over what the language means. I mean, it's very, very close. In Harvey, we're talking about mixing different parts of the statute. In Cox, he's clamoring out about what does conspire mean. And in Awad, he wants to know what willfully is. And I think the Ninth Circuit in Awad actually worked much too hard in that case to find that it was inferred. The case they cited, United States versus Bryant, says, look, willfully means often it connotes intent. And they charge it with intent to defraud. So under the principles that are kind of swirling around here, there's a lot of them. We think that really, for the most part, those cases came out correctly. Just don't apply here.
Counsel, let me ask you a question. If the day of trial, defense counsel, having a pretrial agreement in hand, objected to the specifications as saying it's a failure to state an offense, and then both sides agreed to modify the specification with a pending change. You would agree if there was consent, we wouldn't be having this discussion.
We agree, Your Honor.
Okay. In this case, it did not happen.
Right.
But the judge then goes on in this case and actually lists the elements. And the accused agrees that those are the elements, he understands the elements, and then he says the element is prejudice to good or discipline. He committed the element of prejudice to good or discipline.
Yes, Your Honor.
How is this not the same thing as making that pending change?
Because it's dragging, Your Honor, a pre-Foster case into a post-Foster world. There could be no major change, in our opinion, at the time, because there's no problem with the specification under Marco and Mayo. That is, they didn't need to put the terminal element in there. So now, after the appellant's tried, and after Foster comes out and says, no, more is needed, you can't just leave it out, to now go back and say, oh, well, that was a major change, and that modification is now going to attach to the appellant, we think is unsupportable. I see my time's up, Your Honor.
Yeah, please. Yeah, why is it unsupportable? I'm trying to track that last comment.
Your Honor, so to make a major change, our understanding is that it would have to be knowing and voluntary. That is, if at the time of his trial, it was ridiculous for the appellant or the defense counsel to challenge the specification because it was well settled that the terminal element simply didn't have to be alleged. And the accused is, based on argument, is been actually forced in a way to go to trial because he couldn't properly prepare a defense. It just doesn't follow by my logic anyway, that, well, after the fact, after Foster comes out, we can now say, well, oh, that was actually a major change that he agreed to. He simply was pleading guilty, as the court pointed out, to the offense. But there's never any discussion about, oh, the government actually has to place this in there, and they haven't. Do you understand that? Do you understand that there might be some problems with your PTA if you don't agree to this major change and so forth? None of this discussion is taking place. This is a straightforward guilty plea based on that 60 years of Marker and Mayo precedent.
Counsel, to what degree does the appellant believe that Watkins remains good law post-Foster?
Watkins, to the extent that Watkins does any kind of prejudice analysis, Your Honor, it has no import anymore. It's been overruled by Foster. But we do believe that the principles announced there, that is, that you can look at the specification more liberally and the standing aspect are still valid. You just don't want them to apply to your client. We don't think it would be fair to apply them here, yes, Your Honor. If there are no further questions, that concludes my argument at this time.
Thank you.
Good morning, may it please the court. I'm Captain Sam Moore, and along with Colonel Brubaker, I represent the United States in this case. This case is not Foster for three reasons. First, it is break and restriction. It's not adultery. Second, it's a guilty plea, not a contested case. And third, and most importantly, the accused in this case did not object to trial. And it's this third factor which is most important to this court's analysis for two reasons.
Counsel, could you articulate for me where within the four corners of Foster we're advised that it has to be a guilty plea in order for Foster to apply?
It does not say that expressly, Your Honor, but it's pretty close. They go to great lengths throughout Foster for whatever reason, whether it's disagreement among the court members or whatever they have to do to get a majority in that case. Great lengths to specify that Foster and its holding is limited to a contested case dealing with adultery specification where the accused did not object to trial. Where half may go in the future with Foster and its holding is unknown. But as of today, we have Foster and we have the 60 years of precedent that's not impacted by Foster. Two ways that the lack of objection changes this here is first, when reviewing for error, this court looks at the charge and specification with maximum liberality. Second, if there is error, that is not enough. The accused must show plain error in this case. First, with the charge and specification.
The basic problem is identical with the problem in Foster, correct? The sovereign was derelict in not addressing the terminal element within the four corners of the specification, and then entered into a pretrial agreement which, on the four corners of the pretrial agreement, again articulates the specification without the terminal element. So what you're asking us to do is to absolve the government of this dereliction, ignore the mandate of Foster, and in essence read CAF's tea leaves because they go out of their way 5, 6, or 7 times to indicate that the case before them is in fact a not guilty plea, a contested case, and where a motion was raised at trial.
The government is not asking this court to predict anything. The government is asking this court to apply Foster in the 60 years of precedence that was not overturned by Foster.
What part of Foster do you want us to apply? That's my point. Foster seems to give us solid, firm reading of what the state of the law is, which is that no matter what the trial judge does by way of placing a respirator on the government's deficient specification, he or she cannot resuscitate that specification, notwithstanding any great intent, just as in Medina they talked about this dynamic. Isn't that all we're left with? Where's the Foster exception? I mean, I know you're sharing dicta with me, which I share the concern with you on. And I think you're being very, as you always are, very articulate and genuine with this court. But where can you show me within the four corners of Foster where this court can take safe haven and be sure that in a guilty plea scenario the answer is totally different?
The easiest and most direct way to answer that is the court's citation to Watkins, repeatedly. They cite to Watkins repeatedly in Foster for the proposition, and they use a CF, so really the opposite proposition, which is if you object to trial, we're going to view it narrowly, which is absolutely in line with CAF precedent, Supreme Court precedent. That is the appropriate standard. And if they had objected to the charge and specification trial here, and it was not, the objection was not granted, then it would be a different analysis, absolutely. But they did not object. And because they did not object, this court should review the charge and specification with the broader lens, with the maximum liberality standard, which is appropriate both in CAF case law and in Supreme Court precedent. With that broader lens, and with the charges in Article 134 offense, and with the particular words in the specification here which are important, which is, that he was restricted by a person authorized to do so, that he did break said restriction, that together with a maximum liberality reading necessarily implies the terminal element here. So it's not, going back to the question, it's not a deficiency that the government is asking this court to overcome. It is a correctly charged and pled offense in this case. Could the terminal element have been expressly applied? Absolutely. Could have been expressly alleged, but it was not. Nonetheless, it still states an offense in this case, particularly under maximum liberality reading. Even if it does not state an offense, though, Your Honor, any error must be reviewed for plain error. Once again, if they objected at trial, it's a different analysis and a different standard. When you object at trial, though, when you do not object at trial, plain error is the appropriate review. But once again, Watkins is, CAF points to Watkins. Watkins looks at both the four corners of the charge sheet and some of the other events that took place. In the government's view, Watkins is absolutely good law, but it conflates to some extent the error and prejudice analysis under a plain error type review. So the government would ask this court to apply plain error analysis, but to separate out between what is potentially error, which the government certainly argues is not, and are the other prongs of plain error analysis met. Under the plain error analysis, obviously the appellant would have to show both error that is plain and obvious, and it is not a flip-flop from the government that we're looking at that plain and obvious reading. Is simply taking CAF's own words and Foster. Whatever the government may have believed, whatever the government may believe, that is the words that CAF used, which is drawing on the long line of cases going back to Schmuck. This issue has been in play for a while. That is why the government starts using their own words, their own logic, that this was not plain and obvious. Nonetheless, the third prong of plain error analysis in that review is that there has to be material prejudice to substantial right. In this case, of all cases, there is certainly not material prejudice to substantial right.
Do you know of any cases where CAF or its predecessor court applied a plain error analysis to failure to state an offense?
Not specifically to that point, Your Honor, because as the government And as I argued, Watkins conflates the issue between error and potential prejudice. So, not directly.
Or that portion of Watkins which still lives.
The government asserts that Watkins as a whole still lives, Your Honor, and that Foster did not affect Watkins or its holding in any way. But throughout the past 10 years, CAP has every time applied plain error analysis to the LIO line of cases, which is an analogous situation here, where if an appellant is charged with an Article 118 or Article 119 and convicted of an Article 134 offense, they're saying he was convicted of an offense that was not on the charge sheet. If there is potentially error here, it would be the same situation where they're convicted of an offense that's not on the charge sheet. For that reason, just as they applied plain error analysis in Jones and in Girard and McMurray, and in all of those cases where there was no objection to trial, that is what this court should do in this case. Without an objection to trial, plain error analysis is the appropriate standard of review. And the citations from the defense to Resendez-Cross and to Russell and Hamlin, and even throughout the years, those cases all have objections at trial, which means the court is simply looking at were they correct in what they were asking for, and maybe there could be a harmless error type analysis. But without an objection at trial, when it's raised the first time on review, the plain error analysis is the only appropriate standard of review. There is no other, unless it's structural. But since it's not structural, plain error is the only standard of review without an objection at trial. Here, if this court finds any error if they find error in the charge of disposition, there's certainly not material prejudice to substantial right. The appellant had, as he points out, the historical precedent of 60 years and knew it would be fruitless to object at trial, indicating that they knew the terminal element was required. They had the MCM, they had the historical precedent, which is not overturned when you don't object at trial by Foster. They also had the colloquy with the judge, and this is the difference between analyzing whether there's error and whether there's prejudice. Appellants in a brief point out what they argue is a contradiction in the government's argument. It is not a contradiction to look outside the charge sheet when you are looking at error and prejudice, When you're looking solely at error, though, that's where you look at the four corners of the charge sheet. Once you get to prejudice, the court says, what right are we really protecting here? We're protecting a Sixth Amendment right to notice. Does the accused, does the appellant, when he sits in trial, know what he's defending against? And they say, with that in mind, we can look at everything that took place. The judge's own words, the colloquy, the historic precedent, the MCM. In light of all of that, that right to have notice of what he was defending against was certainly preserved here, and he was in no way prejudiced. So as a result, there can be no material prejudice to substantial right in this case.
I recognize the government wants us to apply the plain error test. If you go back to 1983, it was a case of United States versus Schwartz. It's 15 MJ 109, where the court it was a guilty plea to a forgery, where the court is trying to assess the impact of a deficient specification. And in there, the court says, look, when we go through it, it's fairly obvious that it's missing two elements. Specification fails to actually allege that the forgery would apparently impose a legal liability on another or change his legal right or the liability to his prejudice. That's not there. What the specification said was that the guy had executed an allotment. And the way the court resolves it is by saying, look, everybody knows what an allotment is. I mean, common usage, we understand what an allotment is. You understand that's causing money to flow. We can look at that and decide that, by fair implication, the elements were all there. But they go on to discuss the resolution of this, where they first say, look, we don't look kindly on attacks to specifications for the first time appeal. He's pleaded guilty. They say he raised no objections under the circumstances. We're satisfied that he knew. And then they go through all of these things that you've discussed, which is, it's a guilty plea, a negotiated pretrial agreement. There was a providence inquiry. They don't talk about prejudice, but they're talking about notice. And they resolve all of this based on, not on plain error, but rather on, look, the notice was sufficient under the circumstances where this is a guilty plea. So having a case that appears to give us the correct legal analysis of this, again, realizing this is 1983 and it's really prior to the point where our court system began relying on the legal test of plain error, I'm wondering whether this isn't the test we ought to apply. Just look at sufficiency of the notice.
No, that is very similar to Watkins. And it is.
It is. It's very similar.
In a sense, absolutely, that's the analysis this court would apply. And it's similar to what this court has done in recent post-Foster cases. But at its heart, it is still discussing two things. One, is there even error in the first place? If there's no error and viewed with maximum liberality as states an offense, then that can end the analysis. No further analysis is needed. In a lot of those cases, what they're doing essentially is saying, not only is there no error, and maybe we're not really sure if there's error or not, but certainly he was not prejudiced. They're saying, look at all these factors. The PTA, the guilty plea, the stipulation of fact, the providence inquiry. They say, in light of that, his Sixth Amendment right to notice was certainly preserved. The government asked this court to do that, but to break that out into its component parts among plain error. Just like Watkins does that same analysis, the court, and it's still good law, in a sense, in its holding, the government asked this court to break that out into its component parts because the government submits that that is the standard.
Counsel, isn't there another way to look at this, though, just playing devil's advocate for a moment, that the government has slowly been given a legal practice and history lesson by the courts above, starting with Schmuck, moving on into Medina, moving on into a couple other cases, and finally, the final exam is Fossler. And the instruction in each of these cases is, hey, sovereign, watch what you're doing. Don't be deficient. Don't be derelict. If you're going to charge a sailor or marine with something, charge them. State the elements. And for whatever reason, trial counsel, convening authorities, staff judge advocates, etc., in our system have, for whatever reason, been recalcitrant in doing so. And so finally we end up with Fossler. And with Fossler, Judge Stuckey and his majority finally put it to the government and say, you haven't been listening. And they articulate I take this from your brief, in a line of recent cases drawing on Schmuck, we have concluded that the historical practice of implying Article 134's terminal element in every enumerated offense was no longer permissible. In judicial terms, those are fighting words. Would you not agree? And that being made the mainstay of the state of the law, aren't you really asking us to blink in this particular case, apply plain error, because it's the only road home to victory for you? Because if we use Fossler as the plenary opinion that it might well be, you lose.
No, Your Honor, because that is not what Fossler stands for. The easiest example would be to look to Supreme Court precedent, to look at the comparison between Apprendi and Cotton, which came out 2 years earlier. In Apprendi, when you go back to trial, the accused objected, and they preserved the error. As it went out to the Supreme Court said, you objected, you preserved this error. It's a different standard of review. Let's see if what you're saying is right, your underlying statement. 2 years later, with the exact same issue, Cotton, the Supreme Court once again did it, and without an objection trial, the Supreme Court dismissed it. They just said, look, you've not shown plain error. You're not even close, particularly under prongs 3 and 4. You can't show any of this. Go home. I'm sorry, there is maybe an underlying error, but that is not enough. The standard is plain error analysis. And in this case, if they objected to trial once again, Fossler would be very persuasive, and we'd have to analyze whether the distinction between a guilty plea and the distinction between an adultery case and break and restriction is dispositive or not. But it'd be much more on point. But without the objection at trial, this is just a different case and a different analysis. So first, the government once again argues there's no error, but even if there is error, unlike Fossler, and the court can look back to Jones, for instance, where they do the plain error analysis in a footnote, I believe, and then in Gerard and McMurrin, where it's somewhat cursory, but it is there, the plain error analysis. That is the standard that applies when the appellant does not object to trial. So it is not...
Well, you'd agree with me, as you did in your brief, that in none of those cases, while they seem to subliminally apply aspects of plain error, they don't come out and say, hey, military world, you must apply plain error in the following scenarios. Is that not the case?
The government would disagree in a sense. There's not the central holding of any of this case. I mean, it is the holding, but it's not. They do not spend pages and pages of discussing plain error analysis. But in every case, they actually, where there's no objection to trial, they apply it. Whether it's in a footnote, and then it's a little more robust in Gerard and McMurrin, which is their least recent cases on this issue, they're absolutely applying plain error. They're saying, if error, that is not enough because you did not object to trial. Is it plain and obvious? Is there material prejudice to substantial right? And then they're getting into their disagreement about the application of the fourth prong. The plain error analysis is absolutely the correct analysis when there's no objection trial. And that is why, even if this court applies Foster to find error in this case, that does not end the discussion. Once again, the lack of objection goes back to how this court should read the charge and specification and into what would happen if there is, if this court were to find error in this case that does not end it. In light of that, and in light of the historic precedent, in light of the applicable legal standards, this states an offense and there's no plain error. Finally, the appellant cites generally to fairness as the legal standard throughout. Fairness is not a legal standard. The standard is there error and is there plain error? Nonetheless, fairness is appropriate. Fairness is appropriate, though, not just from the accused, who had actual notice in this case and is certainly not prejudiced, but to the judicial system as a whole. When an appellant pleads guilty, when he says he's guilty, when he has every notice provided to him by the military judge, by the precedent throughout, and when he is found guilty and convicted, that is fair to affirm that charge and specification. As a result, based on the applicable legal standard and based even on fairness, as appellant wants this court to apply, the government asks this court to affirm appellant's convictions and sentence.
Do you think that, not quite yet, Captain, you're doing very well, but not quite yet. Do you think that when the trial judge interposed the terminal elements by way of definition when the plea was being taken, he was tendering substantial change to the specification as it existed before the court at the time?
Fundamentally, no, Your Honor, because the charge of specification stated an offense, so it did not need change. It could arguably be a major change to the charge of specification, but that is not necessary.
Well, let's play down the theoretical role for a moment. Let's say, for instance, it is. And ordinarily, the appellant would be allowed, I believe in this case, 3 extra days, and we'd go forward. And who is to say what the convening authority might have done with these charges after that renewed tenure of time? How are we to know what may have happened if, in fact, the trial judge had afforded counsel and his client the opportunity to claim this as a major change? And isn't that, per CAF precedent, an obligation of the trial judge? It's not a burden for the appellant.
Once again, fundamentally, the government does not believe it was a major change. But if it was a major change, the 3-day wait or 5-day, depending on the forum, could be waived by the appellant. And it was waived here by not exercising that right.
Well, it's never articulated in the record, correct?
Correct, absolutely.
Right.
It's not expressly stated on the record because it was not a major change. The major change discussion that takes place in Gerard, McMurrin, and footnotes, and then throughout, is going more to the jurisdiction of the court-martial, and that's a referral question. The question Gerard and McMurrin is, and Judge Baker is really points this out, and that's why the court starts addressing it, is if you were saying that Article 118 and 119 does not have Article 134 as a lesser included offense, as Judge Baker points out, and if you're saying the convening authority referred Article 118 and 119 without the lesser included offense of Article 134, then how could you potentially have jurisdiction over an Article 134 offense to test for plain error in those cases? So to resolve that, CAF has pointed out in footnotes and other places that a major change took place at the time he was convicted, and the jurisdiction dealing with the Article 118 and 119 offense is still present. So we do not have a referral problem. And that's what the major change analysis in those cases is really dealing with. Not whether it states an offense or not, and not really whether they were prejudiced in that case.
Okay. Thank you.
Thank you, Your Honor.
Appellant?
Your Honor, really what the court wants, or excuse me, what the government wants this court to do is overrule an additional 60 years of precedent by testing for prejudices here. As this court asked the government, what case stands for the proposition that can test for prejudice where in the defective specification?
But counsel, but practically, didn't the court do that? Didn't CAF do that again and again and again? Jones is a classic example, where they don't set out, as the government quite genuinely placed in their brief, they don't set out, well, we have to impose plain error here. Yet, in practicum, in the majority opinions, in I believe 3 cases cited, the plain error standard was applied.
In military cases, Your Honor?
Yes.
They're all LIO cases, though, Your Honor. It's just a huge difference, in our opinion, that in all of those cases, the initial charge sheet actually had sufficient charges there. This one never did from the get-go. And when the government talks about, well, no substantial right would have, the court is going to do prejudice analysis that no substantial right was affected. As Judge Baker asked in his dissent, can the accused plead guilty to a specification that doesn't state an offense? To us, there's really 2 deep issues here. If the court finds that the terminal element is implied, then we lose. If it finds that it's not, then we should prevail. Watkins didn't even do a prejudice analysis. In fact, the holding there is really quite confusing because they find that the without authority element of Article 86 is fairly inferred. Now, I don't know if that's the same as necessarily implied. It seems weaker. But nonetheless, assuming that it is, if it's implied, then the game is over. And yet they go on to talk about all of these things. And we don't know exactly what the court was thinking, but it does seem like this was really the element implied masquerading as a prejudice analysis, where the court just said you wanted to plead guilty and do all of these things. But in Watkins, that appellant was not faced with Marker and Mayo. And we think this is a huge distinction, which just the court cannot overlook.
Okay, let's pretend for a minute, though, we are going to overlook I understand why you want to root this back into 60 years of precedent. Believe me, as the author of Fawcett was reversed, I understand why you want to go back to 60 years of precedent.
Yes,
but all joking aside, isn't Watkins kind of instructive, where the element that's missing is what one would argue is indispensable to the offense of unauthorized absence, and that is without authority. I mean, because if he's just absent and he has authority, it's no offense. I mean, they've left out a fairly critical element to that. And yet Watkins is the case that Caff cited for saying, well, there's a contrary standard when you don't attack this at trial. If your argument is correct, then Watkins can't be correct anymore.
I agree, Your Honor. I don't think it's correct. And we talked about McGuire recently that I don't think Caff recognized this. I mean, this is all new to a lot of people. All of us, me not as long as all the distinguished judges, were brought up under this doctrine that it was just mere surplusage. Unfortunately, I'm quite certain some of my clients pled guilty to this or even contested it without it. I never said a word because the manual said it would be dumb for me to do so. So under these circumstances, we think it's hugely different. And the fact that Watkins then goes into this prejudice analysis nonetheless we think really shows where their thoughts were, that he pleaded guilty, he didn't challenge it, and there was no cases out there saying you didn't have to put it in there, and that was enough.
But if the heart of the issue is a due process concern for notice, doesn't that analysis make sense? Doesn't it make sense that, I mean, you can call it prejudice, you can call it whatever you want, but doesn't the analysis make sense to say you're going to do a searching record of when the guy pleads guilty, a searching inquiry of the entire record to determine, okay, is there any indication that he didn't know what it was that he was admitting to? He didn't have the opportunity to prepare for trial. Again, putting aside the argument that he somehow was coerced because of 60 years of bad law. But, I mean, that's what you see in Swartz as well, the case that I was just citing to, this idea of saying, yeah, it's missing 2 elements, sure, just like Watkins.
I'm out of time.
Yeah, please.
I agree with you, Honor, that this is about a notice aspect. And I'm just afraid I can't move away from our argument that Marker and Mayo affect this in a huge way. If the court doesn't buy that argument, I think we have a tougher road to go. But I fear I'm not articulating it well enough because I think it's such a strong argument.
Well, let me ask you a follow-on then. If that's true, does that mean that every case prior to 2011, since 1952, now under Article 134, where it's been pleaded without the term element, now must be reversed because every one of those people falls into the same boat that your client does, which is, gee, they had no idea that they had the opportunity to contest that specification.
Yes, Your Honor. My peers had that same concern, Your Honor. And we don't think, as a matter of fact, we know that well, I think I've lost your question, but any case on direct appeal, when Foster came out, gets the same treatment. So these 60-some cases, in our opinion, yes. I mean, if there's some slight differences in each.
Is that fair when for 60 years all of these people have been relying on this horrendous law that has coerced them into pleading guilty?
Yeah. It may not be fair, Your Honor, but it's the way that the Supreme Court has ruled that that's what happens.
So this isn't a watershed moment per Teague?
No, Your Honor.
Where we go back and do a root canal on all the old cases?
Well, in Teague versus Lane, Your Honor, what the court distinguished between a major, just a flip-flopping of the rule and an exception that was carved out, and all those people who were in that exception should get the benefit of it. But under Apprendi, under Cotton, and under Teague,
or Griffith versus Kentucky, where a new rule for the conduct of criminal prosecutions is to be applied retroactively to all cases, state or federal, pending on directive review or not yet final with no exceptions, in which the new rule constitutes a clear break from the past, and then goes on to articulate how retroactively it could be applied to cases where appeal has been completed, depending on the due process aspect. Aren't you making a due process argument here?
We think the finality of a conviction, Your Honor, is going to be when CAF either reviewed the case or rejected the petition and the accused was discharged, or the appellant, was discharged. We think the case law is very clear on this. The only cases that would be set aside would be those that are on direct appeal.
So any case coming up quorum nobis to our court, petitioning for relief, those cases would find no safe haven here, according to the appellant in this case.
We agree, Your Honor. And if I can just sum up on that particular issue, Your Honor, also say that as a practical matter, we don't think you'll see that many of them. And second, these 60 or 70 cases that are trailers to Fossler, the effect, or I guess the pains the military will have to go through to finish them up should be, we think, in the majority of cases, slight. That is, 134s are often just tack-on charges in which a sentencing landscape will not change, which we believe to be the case here as well. Many other cases, the convening authority would not choose to do anything differently and so forth. So we don't think it's going to be a real problem at all, other than, in the end, they'll have one less conviction on their charge, or in their record. If there are no further questions, that concludes my report.
Thank you. Thank you both sides. Great argument. Matter submitted.
All rise.